Yes, good evening to everybody. Welcome to the today class. And today that I'm going to do the negligence. See, the first class I did negligence. The second round also I did the negligence. And this is the third round that I'm doing the negligence. Yes. Could you know that why I'm dealing the three times and three classes for the negligence only? Anyone? Anyone? If you know it, you tell me. If you don't know it, you say pass on. Hurry up. I said hurry up.
Pass on, sir. Pass on.
But you are taking so much time when you don't know, pass on. I told you in my class what I said. Negligence is a genus. Negligence is a genus. Carelessness is a species. Negligence is a genus. Rashness is a species. No negligence, no tatla. I repeat. No negligence, no
Tatla.
no tatra. Because everywhere the negligence plays an important role in one way, in another way. Suppose defamation, if you voluntarily defame somebody in the right thinking of the people, negligently and intentionally, it's a defamation. When you're driving rash and careless because of the negligence, there is an accident. If you detain any person without any legal justification, it is also negligence. Are you following me? Say yes.
Yes, sir.
Yes,
Yes,
read
sir.
what I put on the screen.
Good
Read.
evening, Professor Dr. M.S. Hussain.
What about this one? Which I am.
It's a symbol of caution.
It is a.
Exclamation mark.
It is a.
Exclamatory mark.
No. When it is a triangle, the sign shows number one, danger, number two, negligence. Is it clear?
Yes, sir.
When it is not in triangle, then we can say it's an exclamatory mark. So now let us see where we stopped yesterday. We stopped in the Donovan versus Stevenson. There is no break of the chain. That means novus actus intervenience is not there. Means new act not intervening. The reason is the ginger bee is manufactured in the plant breweries, and that is sealed. Yes. You are speaking or you are asking any questions? Sai Krishna.
No, sir. Sorry, sir. It was unmute.
Sai Krishna, whatever you speak in your house, I could hear you. So when you speak in the house, yes, that's why I'm asking you. You mute it. When I ask the question, then unmute and give me the answer. Because whoever speaks, it will be highlighted on the screen on my laptop. Okay, now let us see how it will work over there. So there is no breaking of the chain from the manufacturing unit till it reaches to the consumer, who is a neighbor, and there only in front of him the seal bottle is opened. So that means when there is no break of chain, then the first one who caused it, and he would be held liable. That means manufacturing unit is held liable. So novus actus intervenience, that means a new intervening act. In the law of delict, it is a novus actus means breaks the causal chain between the initial wrongdoer's action and the liability that is imputed to him or her as a result thereof. So if anybody comes in the middle, then from there the liability falls on him if the chain is broken, because it is he who broken the chain. then he will be held liable. Let us see one or two cases so that we could know what actually the breaking of the chain, not breaking of the chain. Because generally, this novus actus intervenience comes under the short question. Suppose if it is given in the long question, you should have to write in at least the ingredients of it. You have to write some 3 or 4 the case laws also. Let us see the Well-Bundle versus Stephen case law. The appellant employed the respondent, a chartered accountant, to investigate the affairs of a company. So he gave a written instruction which contained the matter which was libelous of the 2 officials of the company. And here the respondent passed this instruction to his partners, and who carelessly left them on the floor of the company's office. The company's manager found them and communicated the content to the official, who then recovered damages for the libelous from the appellant. Then the question comes over there. What is the duty of a chartered accountant? Yes. What is the duty of a chartered accountant? Sir, we don't know, sir. Say you don't know. Pass on.
Pass on, sir.
The chartered accountant is appointed to see your assets and liabilities, and he will make a statement and report to the income tax. See, these are the sales, these are the expenditures, and these are the what is bonus, and this thing, and this much is the income tax. So he will submit it returns. So every company should have to go through the accounts, and if the tax, they have to pay it depending upon the income. So chartered account, what he did it, in addition to the showing the table of the assets and liabilities, the statement, he has given written instruction containing a matter which was libelous, and he wrote one libelous statement regarding the 2 officials. It is not his duty. He has to show that, yes, these are the mistakes, we found it, or these are the corrections, we did it. That much. So this libelous matter will be read by one of the appellant, respondent, left over there, but it is he who created this thing, then it is he who is held responsible. So who wrote the libelous statement? Who wrote the libelous
Chartered
statement?
accountant. The chartered accountant.
Who is the chartered accountant in this case? Here the appellant appointed the respondent. The chartered respondent is the chartered accountant.
Respondent.
Isn't it? The appellant employed the respondent, means a company appointed the respondent. Then this respondent, chartered accountant, to investigate the affairs of the company, and he gave a written instruction which contained the matter which was libelous of the 2 officials of the company. Who? Respondent. At that instance, then it comes, the appellant could recover nominal damages only, because it is not the duty of the respondent to write such a libelous statement. So it is a wrongdoer, and he will be responsible. So let us see that where the exception to the rule of novus actus intervenience will come. Number 1, where the intervening act has been intentionally procured by the defendant. Number 1. Number 2, where the intervening actor is not fully responsible. Number 3, where the intervening act is such a could be reasonably anticipated. Number 4, where the intervening act is mere reflex or involuntary action, then the novus actor inconvenience will not be applicable. That is the exceptions. So actually, what is that? The first principle is, it is a test of the foreseeability, which refers to which such a happening could have been anticipated by the defendant as to know the degree extended harm it may lead to. So this novus actus inconvenience will be see whether who will be held liable, to whom that you have to make them liability. So if the chain is broken, then a person who broken the chain, he will be held liable. If the chain is not broken, then the person who did the first mistake, wrongdoer, he will be held liable. So an example you will see here, who has the break and the chain and who has not break and the chain. Better we'll go with this example. Yes, this is a very good example. The Oropesa is the case law name. To this effect, we will see the Oropesa case law. The plaintiff ship, Manchester Regiment, is a plaintiff ship, was damaged due to collision with the defendant ship. The defendant ship name is the Oropesa. The defendant ship name is Oropesa.
Yeah, Oropesa.
Then, sir, ikkada accident enduku analedanడి? Damage due to the accident with the defendant ship enduku analedanడి?
షిప్స్ కొలైడ్ అవుతాయి కాబట్టి కొలిజన్ అన్నారు సార్.
Generally, they collide each other, then say collision, we will use it. And that is the reason, due to the collision, and there will be what is a head-on collision, also the head-to-head collision, direct collision, hit. So there is a collision between the two. One is the plaintiff's ship Manchester, and the defendant ship is Oropesa. In an attempt to discuss the situation with the defendant ship's captain, let us see how the collision has make it out. What is the consequence of the collision? There, the defendant ship means whose ship? Oropesa. The defendant ship's captain, who drives the ship, is called
Captain.
captain. Don't say driver. Don't say pilot. Don't say carter. The captain and 50 crew members. Then the captain, along with the another 15 members, attempt to travel across, which result in the overturning of the boat. They were riding. They were riding, they were riding, causing the death of the captain and several members of the crew. ఈ కొలిజన్ వల్ల ఏమైందండి? ఇది ఓవర్టర్న్ అయింది. ఇక్కడ మనం దోస్ హు ఆర్ బోట్, దే వర్ రైడింగ్ అనాలి అండి బోట్లా. విచ్ వాజ్ ద అప్రోప్రియేట్ వర్డ్? రైడింగ్ అనద్దు, sailing anala. Appropriate word is sailing. Boat, they were sailing, causing the death of the captain and several members of the crew. Okay, good. The dependents of the deceased means the dependents of the deceased, dependent, sued the defendant. And the defendant ever ikkada Oropesa. The court held that the death caused was an implication of the original harm. There was no intervening acts in between. Ikkada collusion la ఏదైనా ఇంటర్వీనింగ్ యాక్ట్ ఉన్నదా అండి? బికాస్ ఆఫ్ ది కొల్యూషన్ ఓన్లీ ద ఒరోపేసా బికమ్స్ టాప్సీ టర్వీ, తలకిందులు అయింది, ఓవర్ టర్న్ అయింది. ఇస్ ఇట్ ఆర్ నాట్? ఇఫ్ ఇట్ ఈస్, దీన్నే కొంచెం ట్విస్ట్ చేస్తా నేను. దెర్ వాజ్ ఎ కొల్యూషన్ అండ్ ఒరోపేసా ఆ ముందటి భాగాన్ని ఏమంటారండి? షిప్ ముందటి భాగాన్ని
Head, tip.
Yes. The front part of the ship is called.
Head part of the ship, sir. Head, sir.
అన్నారు ఏమంటారంటే బౌ అంటారు. BOW బౌ అంటారు. ఏమంటారు? BOW బౌ. సార్ కోస్తాను రా సార్, నిజంగానేనా? బౌ అంటే అది కూడా అవుతుంది, యారో అండ్ బౌ. అది ఫాలోయింగ్, ఇది కూడా బౌ అవుతుంది. చూసినరా? యారో, ఇది కూడా బౌస్ అవుతాయి ఇవి. దెన్ ఇప్పుడు నేను దాన్ని బౌ వెస్సెల్ అన్నాను అనుకోండి. చూసినరా? ఇప్పుడు ముందటి పాడు కనబడుతుందా లేదా? కోసిన నానే నిజంగానే చెప్పినా?
నిజంగానే చెప్పాలి సార్.
ప్రొఫెసర్ హుస్సేన్ very rarely commit a mistake. Okay, now that is a bow got damaged. After some time, the heavy turbulent waves make the Oropesa topsy-turvy, overhead. That caused the death of some person. అది యాక్ట్ ఆఫ్ కార్డ్ కింద వస్తుంది. Because the second act intervention everything
God.
act of God. Heavy torpedo has come over there, heavy violent turbulent waters is disturbed over there, then it is there అయింది. లేకుంటే సునామీ వచ్చింది అనుకుందాం కాసేపటికి, ఏది కొల్యూజన్ అయిన తర్వాత. మీన్స్ ద చైన్ ఈస్ బ్రోకెన్, ద చైన్ ఈస్
Broken.
బ్రోకెన్ అవుతుంది. దాన్ని ఇఫ్ ద చైన్ ఈస్ బ్రోకెన్ హూ విల్ బి హెల్డ్ రెస్పాన్సిబుల్? యాక్ట్ ఆఫ్ గాడ్కి ఎవరి రెస్పాన్సిబుల్ అండి?
Only God is responsible, sir.
If it is insured in the terms of the contract of the act of God, then the insurance company will come to the rescue. All the ships, heavy premium they will pay it, because ship cost also heavy. Are you following me?
Yes, sir.
Yes, that is the reason. ఒకటి చెప్తున్నా సార్, మీరు దీపావళికి ఏమేమి కలుపుతారండి? దీపావళికి
Crackers.
ఏంటిది అవి పేర్లు చెప్పండి ఇంగ్లీష్లో.
1000 wala.
సార్ రాకెట్ సార్, సార్ భూచక్రం సార్, సార్ విష్ణు చక్రం సార్, సార్ తాసుపాము సార్, పాము. వాట్ ఆర్ ద నేమ్స్? అందులో
Sir,
ఒక
sir, I have-
స్క్విబ్ అంటారు, ఒక
Sir,
స్క్విబ్
I have a
అంటారు.
doubt, sir.
ఎస్, ఒక స్క్విబ్ అవుతుంది. అది ఏంటంటే ఏ స్మాల్ ఫైర్ వర్క్స్ దట్ బర్న్స్ విత్ ఎ హిస్సింగ్ సౌండ్. మన కాకరవత్తులు అంటారు చూడండి, కురుకురు కురుకురు హిస్సింగ్ సౌండ్తో వెలుగుతాయా లేవా కాకరవత్తులు? సో ఎస్
Yes,
సార్,
sir. Yes, sir.
ఎస్. సో ఇట్ ఈస్ విత్ ద హిస్సింగ్ సౌండ్ అండ్ ఎప్పటి వరకు బిఫోర్ ఇట్ ఈస్ ఎక్స్ప్లోడింగ్, దాన్ని స్క్విబ్ అంటారు. మనకు కావాల్సింది స్కిప్. ఇక సరే వచ్చేసినాం కాబట్టి హైడ్రోజన్ బాంబ్, బుల్లెట్ బాంబ్, బిజ్లీ బాంబ్, రాకెట్, అనార్, ఫ్లవర్ పాట్, చక్రీ, స్పార్క్లర్, ఫుల్జడి. ఫుల్జడి అని తెలుసా అండి? కాకరవత్తులు, స్నేక్ పిల్స్. సో హియర్ ఇన్ అవర్ కేసులో వాట్ ఐ నీడ్ స్క్విబ్, SQUIB, స్క్విబ్, అది కావాలి నాకు. సో ఇన్ దిస్ కేస్ B, a person threw a lighted squib into the crowd, which landed on X. X మీద పడ్డది. మన కాకరవత్తులు చూడండి, మనం చెట్ల మీద వేస్తాం, చూసారా అండి? చూసారా లేదా?
Yes, sir.
Yes, sir.
వేసారా లేదా?
Yes, sir.
అది ఎట్లా ఉంటుంది? వి ఎంజాయ్ ఇట్. ఎందుకంటే అది కొమ్మల మీదకి వెళ్ళి పడతా ఉంటే వీ విల్ ఫీల్ వెరీ హ్యాపీ. సో దిస్ ఫెలో హ్యాస్ త్రూ ఎ లైటెడ్ స్క్విబ్ ఇన్ టు ద క్రౌడ్ విచ్ ల్యాండెడ్ ఆన్ ఎక్స్. ఎక్స్ ఇమీడియట్లీ ఏం చేశాడు? ఆల్సో త్రూ ఇట్ ఫర్దర్ ఇట్ వుడ్ ల్యాండెడ్, అంటే మీన్స్ ప్లేస్డ్ ఆన్ వై, అండ్ హూ అగైన్ రిపీటెడ్ ద యాక్ట్ థ్రోన్ అల్టిమేట్లీ ద ఎఫెక్టెడ్ పీ. అండ్ యాజ్ దెర్ వాజ్ ఎన్ ఎక్స్ప్లోజన్, నేను చెప్పాను కదా స్క్విబ్ ఆఫ్టర్ సుర్ అన్న తర్వాత ఇట్స్ ఎక్స్ప్లోడ్ అని. Then the explosion caused and ignited squib, leaving P blinded in one eye. అది P మీద పడ్డది. Then he became one eye blinded. అసలు ఎవరితో పైన వేసిండ్రండి? ఇది D వేసిండు. మరి మధ్యలో ఎంతమంది వచ్చారండి? ఇంటర్మీడియట్స్. X is there,
ఇద్దరు సార్,
Y
ఇద్దరు
is
ఇద్దరు
there.
X and Y.
Are you following me? X is there and Y is there. Then lastly it fell on the P. By the it reaches the P, it is exploded. And because of the explosion, he lost one eye. Who lost one eye?
P, sir.
P.
He
Capital
lost
P.
one eye. He became blinded in one eye. Because of the act of, the first act of,
Y.
the first act
D.
of,
D.
the first act of,
X.
act ఎవరిదండి? ఫస్ట్ యాక్ట్ ఎవరిది?
X.
D.
X
D,
ఇది
sir.
కాదు, ఫస్ట్ యాక్ట్ అన్నా.
D. D, sir.
D is the first act. Next X, next Y. But immediate is Y is there. Can Y is held liable? Can X
Yes,
is
sir.
held liable?
Y is
Because
held liable.
they came in the intermediate. Answer is, even though they came between the D and P, X and Y, they are not intervened because they want to protect themselves. So again they threw on the sky. So when the B threw the lighted cube into the crowd and which landed on X, X with the fear to protect him, again he threw the cube on the in the air. Again it fell on the Y. Then Y again, because he knows that it will explode at the last. The cube exploded at the last. Again Y thrown it, but unfortunately when it reaches to the P, it is exploded. Then P lost one eye. Living blind, one eye. The court ruled that irrespective of the intervening acts of
X and Y.
X and Y, the harm caused to the P was the result of the action that was initiated by
D.
D, and was because of D, his defense for the novus actus intervenience was rejected. What the defense is D is taken?
Novus acts intervenus.
Who are the intermediaries?
X, Y.
X, Y was rejected on the ground of his act being causa causans. Means he is the real causa of the causans. Means cause of the cause, he is only the person. So who? D. So chain is broken or chain is not broken here?
The chain is broken, sir.
Not broken. Even though X and Y is there, chain is not broken because X has thrown it to protect himself. Y has thrown it to protect himself. Then finally, it is exploded on the eye of the or the face of the P. But who is the wrongdoer?
D.
D is the wrongdoer. So took the defense, sir, chain is broken, X. అరే నువ్వు ముందుగా చెప్పురా బాబు, నువ్వు పైన ఎందుకు ఇసిరేసినావు నన్ను? నువ్వు ముందుగా చెప్పు నాకు. యూ ఫస్ట్ టెల్ మీ, సార్ అది కింద పడుతుందో లేదని ఇసిరేసిన సార్. అట్లనా? అంటే న్యూటన్ ఏంది వాడు విధవనా ఏంటి? సారీ, కెన్ యూ మేక్ ద న్యూటన్ ఈజ్ ఎ ఫుల్ ఎనఫ్?
No, sir.
Because
He's a
of
genius.
the gravitational pull, everything which is having the mass will not float, it will come down. Are you following me?
Yes, sir.
Yes, sir.
So the Newton, I beg the pardon, because Newton is not a foolish fellow and he's a scientist. He already discovered because of the gravitational pull, everything which is having the weight will falls down. So who is the problem creator here?
D.
D.
D is the problem creator. Even though in the intermediaries are X and Y.
Excellent.
I beg pardon because I used the wrong word. So it will be recorded now. Everything will be known. Okay? So excuse me for that
Sir.
one. Yes.
Sir, I have a doubt, sir.
Yeah, please.
Regarding the previous case law, sir. We discussed about the ship case law, no, sir?
Yes.
Sir, in that you said that the plaintiff ship was the Manchester ship and the defendant ship was Oroposa ship, something.
Yes.
Sir, in the case law, is there any collision, sir? But it is not mentioned in that. I didn't
Collision in the
understand.
traffic survey అవుతుందా అండి? అక్కడ collision అని పెట్టినా కదా, వాడే చెప్పినా కదా ఇక్కడ నేను. See, the
Yes, sir.
plaintiff ship Manchester regiment was damaged due to the collision with the defendant ship, the Oropesa.
Yes, sir. After that, you said that due to some.
The-
Okay, sir, I got it, sir. Sorry,
అక్కడ
sir.
నేను రెండు
Now I got it,
సిచ్యువేషన్లు
sir.
మీకు చెప్పానండి. See,
Okay.
now I twist it అన్నాను నేను. Because of the collision, it becomes topsy-turvy. కానీ ట్విస్ట్ ఏం
Okay.
చేశాను మళ్ళీ అక్కడనే? Even the plaintiff
It
ship
is.
was damaged and the Oropesa bow was also damaged. Are you following me?
Yes, sir.
bow ఎందుకు చెప్పానంటే అక్కడ నేను, the front part of his ship also damaged. Afterwards, there was a high torpedo and there is a high wind. There is a tsunami. Because of the tsunami, if further first situation la topsy turvy అయిపోయింది. Kabatti, there is no break of chain. Second situation, even the Manchester also got damaged and Orpesa also got damaged at the bow. But after some time, tsunami has occurred over there. Because of the tsunami, and it becomes a topsy-turvy, means upside down, turned out. When they turn out, many crew are died or whatever it may happen. So the second act of becoming topsy-turvy, that the chain is broken there. Who broken the chain? Act of God is there.
Act of God.
If it
God.
is a contract terms in the insurance, it is the act of God also included over there. Then the insurance company will come to the rescue. But here, Scott and Shepherd, even though X and Y had indulged in that activity, but they have not broken the chain, and hence actually the problem created is a D who threw it the lighted squib into the sky, and later on it fell down on the crowd, and that is the problem creator. So there is no break of chain. So the defense of the novus actus interveniens was rejected on the ground of his act being the original causa causans. So that is actually the case law where I want to say it. So here also there is another case law is there, but it is also, if there is chain of the break-in, then he will be liable, and chain is not break-in, he is not liable. Let me see that this case law, because we already discussed this case law. Haynes versus Harwood case law, we have discussed it. Can you tell me where we discussed this Haynes versus Harwood case law? Yes? If you know it, you tell me. If you don't know it, say pass on. Yes.
Sir, some persons left two horses on a busy street, sir.
Okay.
Due to the negligence of the person who is taking care of the horses, a small kid thrown a stone or something happened. The horses kept on running, sir. After that,
Okay.
a police
Why the
officer
horses
came
was
and
running?
because they were startled, sir.
Why the horse was startled?
Because of some sound
Naughty
or because of
boys thrown the
naughty boy.
stone.
Yes, sir. Naughty boy has thrown the stone.
Then started and ran violently on
Before
the public road.
public
And
road.
there, the mother and the daughter was there. So children was there. If they are run over by this horse-drawn cart, so who came for the rescue?
A police officer
The police
in the
officer
police
saw the
station.
situation, came to the rescue. Then he suffered the injuries. ఇక్కడ మనం where I cited this case law in the beginning.
Yes, sir. You
If
cited
you
it
don't
under.
remember the name of the case law, if you don't remember the facts of the case law, you are not going to get any marks in the law of tort, because law of tort is nothing but multiplication of the case laws or product of the case law. No case law, no
Tort law.
tort
Tort
law.
law.
అది ఎన్నో విధాలుగా
Sir,
చెప్పాను నేను.
it is under
I told
inevitable
it
accident,
several
I think.
times. I told even given the see read. Tort law is nothing but a product of case laws. Virgule, tort law is multiplication of the case laws. No case law, no tort law. Is it visible?
Yes, sir.
Yes. So this case law we have studied in where?
Sir, I got it, sir. Voluntary non-fit injury, sir. The
Voluntary
police
not
officer
fit
came
injury
voluntary.
and defenses. We studied this case law, where in all the rescue cases, the general defense is not available to the defendant. So D had left his unrated horse van on the street, which amused the children in the melee, and they started pelting the stones at it, result of which it went the haywire and started running. A policeman intervened the scene to stop the horse and suffered the injuries as a result, who then sued for the D for the same. The court held that D would not be responsible for the act of the children that lead to the harm suffered by the plaintiff, as the act could be construed as a intervening cause. Who intervened the cause here?
The policeman.
Policeman.
Even though the policeman intervened the cause, but still, he will get the. Actually, it is not the policeman who intervened the cause. Why the horse startled? You tell me. Because of the students.
Because the child.
Because the child is throwing they are enjoying by throwing the stones on the horse. Child is a naughty. Child doesn't know what is the result of his pelting the stone. And actually, it is he who actually caught. But meanwhile, the policeman has come. But the policeman has intervened to stop but the policeman not the perpetrator here. He is the rescuer. So, the owner would be held liable, not the child, because child is exempted. Child is exempted. Why the owner is liable? Because you are not supposed to keep the horse unattended on the street. Are you following me?
Yes, sir.
Yes,
You are
sir.
not supposed to leave the horse unattended on the street. It is your fault. The owner fault. The carter fault. The person who is driving the cart is the carter, his fault. So he would be held liable. So these are the things where we can say whether chain is broken or whether chain is not broken. So here also the same thing. What happened? Storm has occurred. See, here I told you storm. In this case, which one case? Carlo G Steamship Company Limited versus Royal Norwegian Government. In this case law, the plaintiff has suffered a damage to his ship as a result of the collision with the defendant vessel due to his defendant's negligence. Okay, okay, the collision between there because of the negligence of the defendants. Defendants.
Negligence.
Yes, defendants negligence. What is collided vessel?
Defendant's vessel.
Yes, these damages were further exacerbated, means increased, exacerbated due to the storm in the sea. ఆ తర్వాత ఏమైంది డ్యామేజ్ వాజ్ ఫర్దర్ అంటే ఇంకా exacerbated means hiked due to the storm in the sea. The court in this case held that the defendant's liability can only be accorded till the point of the harm arising out of the own collusion. The defendants know to compensate only for the damage caused by the collusion, not further the one caused by the storm. Are you following me? Because storm is the
intervened
and broken the
chain.
So the defendant is liable only to the collusion, but not what are the losses occurred because of the storm. He will not be held liable because chain is broken. The court observed that the harm caused by the storm was incidental in the nature and can't be traced back to the original harm caused by the collusion. So these are all the cases where we can say whether chain is broken or chain is not broken. Let us see the difference between the novus actus interveniens and contributory negligence. Novus actus interveniens is often confused with the contributory negligence, owing to the fact that it covers within its ambit acts that can be termed intervening on the part of the plaintiff as mentioned above. Supra ante entidandi? Supra.
Above
అన్నట్టు supra ante Latin terminology. For the sake of the claiming, for the sake of eliminating this discrepancy, the time when the omission or commission on the part of the plaintiff affects the chain of the causation is considered. As in, when this act coincides with the original harm caused by the defendant, then it may be attributed as a contributory. And when it takes place post the happening of the original harm, that it may be attributed as a breaking of the causation of a chain. So, where further damage is caused because of intervening act, we can say it is a intervenience act, or because of the own contribution would be there, we can say the contribution. Like without wearing the helmet, how much he contributed? 20%. Can you say, is it a actus, that is novus actus intervenience, not wearing the helmet? No. It's a contributory negligence.
Contributory negligence.
Yeah, that is the difference. So here, for instance, at 10 p.m., Mr. A, PM at night ikkada. PM full form?
Post meridian.
Repeat.
Post meridian, sir.
Post meridian. Good. I appreciate. Mr. A was walking on the wrong side of the road with very low light setting, and Mr. B was coming from the opposite direction without his turning on his headlights, in which leads to the collision which caused hurt to A. Who is at the wrong side?
B.
A is the wrong side. See, here clearly it is written here. At 10 p.m., Mr. A was walking on the wrong side of the road. Then when I asked,
Okay.
they are saying B. It is there, it is visible on the screen itself. Is it not visible on the screen?
Yes, sir. It is visible, sir.
Or can I magnify it?
Visible, sir, visible.
Then
Yes,
you are
sir.
he's walking on the wrong side of the road with the low light setting, and Mr. B was coming from the opposite directions without his turning on his light, which leads to the collision which caused him to Mr. A. This is a classic example of contributory negligence because they contributed one wrong side, another is no light.
Low light.
So both of them contributed something. However, if you suppose that Mr. A was not walking on the wrong side, so A was not walking on the wrong side, is the right side of the road. And initially it was only Mr. B at fault. But post-accident, how if the B come and collided with him, then naturally it's the B fault. Can you say B intervened, or can you say B contribution? He intervened in the middle. A was walking on the wrong. Sorry, this is a classic example. If we suppose Mr. B at fault, however, if we suppose that Mr. A was not walking on the wrong side, so he's the right side of the road, and initially it was only Mr. B in the beginning only. Initially B at fault, and initially B, but post accident, Mr. A did something that aggravated his injury to an extent that it would not have been anticipated. Then it is a novus actus interveniens. If B is there coming after in his own way, and A is also there, what time now? Suppose pedestrian, it is only the one pedestrian path is there where both the people will walk, either going or coming also, unless there is no other pedestrian, the roadside. If only one would be there, suppose A causes something grievous to B, then naturally it is the intervenence convenience in addition to the collision. So that he wants to show over there in this example. But anyway, that in the above example, we came to know that who contributed and who is not contributed. Is it or not? So this
Yes,
is
sir.
all the relevance in the law, how it can be. The overall what I want to say is, to determine whether or not an occurrence or act will carry the legal weight, novus actus interveniens, it must ordinarily be either a human action that is properly to be regarded as a voluntary, a casually independent event, the conjunction which a wrongful act or omission is by ordinary circumstance so extremely unlikely to the term coincidence. The authority of this test is Hubler versus Walker. Again, the another example which is given over here, the same minor leg injury అయిందండి ఎవరిలో హ్యాబర్ అండ్ వాకర్కి. ఎప్పుడు an example of the voluntary human action that could break the chain of causation for negligence may be where plaintiff who has suffered a minor leg injury, okay, because of opposite party, okay, agreed, but due to the defendant's negligence, how the minor injury? Because of the defendant
Defendant's
negligence,
negligence.
ఓకే, మైనర్ ఇంజరీ అయింది. మరి వాడు చక్కగా ఉండాలనా? వాడు జంపింగ్ చేసిందండి, ఎక్కడికి వెళ్ళి? రూఫ్ మీదకి వెళ్ళి.
Roof.
అసలే ఇంజరీ అయిందిరా అంటే వాడు రూఫ్లోకి వెళ్ళి జంప్ అయితే ఏంటంటే అది బ్రేకింగ్ ద లెగ్ అయింది, ఫ్రాక్చర్ అయిపోయింది. ఇప్పుడు ఫ్రాక్చర్ అయిన దానికి డీలయబుల్ అండి? D is liable only for the injury to the leg. But
Yes,
that
sir.
fellow jumped from the roof and breaking his leg was fractured. And here the voluntary human action of the plaintiff would sever the connection between the defendant action. Action వేరే కాలేదండి, ఎవరు
Yes, sir.
ఇంటర్ఫియర్ అయింది, మళ్ళీ ప్లేంటిఫ్ ఇంటర్ఫియర్ అయింది కాదా అక్కడ.
Yes, sir.
Defendant is not liable because the plaintiff himself jumped from the roof. So defendant action or the harm now suffered. Voluntary human action by a third party or by the party himself could break the chain of causation. ఎవరు బ్రేక్ చేశారండి ఇక్కడ causation ని? Plaintiff
Himself.
himself. Is it or not?
Yes, sir.
Yes, that is the reason. కానీ మళ్ళీ ఇక్కడ చూద్దాం మళ్ళీ ఒకటి, ఇది అదైతే అయిపోయింది కదా. పాల్స్ గ్రాఫ్లో కూడా మనం యూజ్ చేసుకోవచ్చు. దాంట్లో పాల్స్ గ్రాఫ్ కేసులో, in this case we also discussed this point. What? No proximate cause is necessary. No proximate cause is not there, number one. Number two, reasonable forcibility is not there. Number three, what is that? Reasonable, there is no duty of care towards the plaintiff. There is no duty of care towards the plaintiff by the defendant. False graph case la ఏంటిదండి సార్? అప్పుడే మర్చిపోయాం సార్.
Yes, sir. We remember it, sir.
Yes. What is jumped out of the railway track and hit the Helen Palsgraf, Mrs. Helen Palsgraf,
A
is
metal
standing
piece.
opposite direction of the platform. What came out and hurt?
A metal piece came out. A metal piece.
దానికి పర్టికులర్ పేరు చెప్పాను నేను, అది వచ్చి కలిగింది.
Yes, sir.
Because the newspaper wrapped cracker fell down on the track, which is the armpit, it is slipped over there. Then for the sleeper and the rails, the fixing scale was there, and the scales came out and hit the Palsgraf, Helen Palsgraf. So while the other employee who was on the platform attempted to push him to the boat train, due to the action of the employees, the man dropped the package which contained the fireworks and exploded when it hit the rails. Due to the explosion, the scales fell from the opposite end of the station and hit another passenger, Mrs. Helen Palsgraf, and who then sued the railway company. The court held that Mrs. Palsgraf was not entitled to damage because the relationship between the action of the employees and the injuries caused to him were not direct enough. Any prudent person who was in the position of the railway employee could not have been expected to know that the package contained the fireworks, that the attempting to assist the man rail. Yeah, the rail car would trigger the chain of the event which leads to the Palsgraf injuries. So there is no duty of care towards the plaintiff. Is it clear?
Yes, sir.
There is no breach of the duty towards the plaintiff. No duty towards the plaintiff or no breach is caused over there. So here again the cases are there. We read it. All municipal corporation versus Delhi. చెప్పండి సార్, ఢిల్లీ మున్సిపల్ కార్పొరేషన్ వర్సెస్ సుభాగవతి ఏంటిదే సార్ ఇది? What is the case law?
The Municipal Corporation of Delhi.
Versus Saubhagavanti. What is the case law? Facts.
Yes, sir. A clock tower due to negligence of the Municipal Corporation.
Chandni
of
Chowk
Delhi.
clock tower maintenance fell
Chandni
down. The case law.
Yes, sir. Fell
So
down.
it is
Pedestrian
a omission of
died.
the duty of the municipal corporation. So that is the breach of the duty to take care. Next, municipal corporation was Delhi. Sushila Devi entity. Sushila Devi, we read already.
Yes, sir.
Yes.
Branch of a tree. Fell
Sushila
down.
Devi case law is a tree. On a highway like both on the tree fell down on his and she became a papad. The branch of tree is standing on the road on his head. So she got injured over there and she filed a case against the municipal corporation. They failed to do. And we already read this, Rameshna, Kumar Naik Union of India case law also. But we did not do the Nagireddy case law. K. Nagireddy versus Government of Andhra Pradesh. ఇందులో ఆర్చర్డ్ అంటే తెలుసా అండి మీకు?
Orchard.
Yes, sir. The
Grape tree,
place
sir.
where
Some
the
kind of tree.
it's
ఆర్చర్డ్
an
లో ఏం
area
తెలుసు?
of
Sir. Grapes.
What do you grow in the orchard?
Grapes,
apples,
sir.
sir. Apple trees.
సిట్రస్ ఫ్రూట్స్ ని పెడతారండి.
It's an area, yes, sir.
నిమ్మకాయలు, citrus fruits. So in this case, the plaintiff had an orchard consisting of the 285 fruit-bearing trees. దానిమ్మని అనుకోండి మీరు, ఆర్ ఆరెంజెస్ అనుకోండి, ఆర్ బత్తాయిలు అనుకోండి, whatever it may be. Okay. The state government constructed a canal under the Nagarjuna project for irrigation purpose. And without the cementing the floor and the bank of the canal, ఏమవుతుందండి? వాటర్ పెర్కులేషన్లో సీపేజ్ అంటారు దాన్ని. Seepage, it passes from the lower bottom, goes to the another strata, percolation would be there. The water releasing from the place, the water reaching to the faraway distance, the most of the water would be goes in percolation. There is a reason what they do, the canal, the down, beneath also they will make the plastering, or the bank also they will make the plastering to avoid the percolation and seepage. Is it clear?
Yes, sir.
Due to the absorption of the excess water from the canal, the seepage will not, if the suppose, if the roots, if the bed is not plastered, or the canals are side canals are side banks of the side canals are not plastered, then the most of the water percolates and goes to the other area. So this orchard, it doesn't need the more water. So the too much water would be there in the roots will be rotten, and the trees are die. The trees will die because of the more
Water.
The plaintiff brought an action contending that cementing the floor of the canal was not done, and bunds also not done. The bunds means side one. The banks, its bunds were not negligence, for which the state would be held liable. The contention was rejected, and it was held that the construction of the project or laying the canal for the irrigation purpose was a great necessity, particularly in Indian condition, and without them the land would be wilderness, the country would be desert, and not cementing the floor or the banks such a big canal was no negligence on the part of the state government. The plaintiff was therefore held not be entitled to any compensation from the state government. Means there is no negligence on the part of the
State government.
Yes, actually, whenever the construction of the canal is there, you see there is a seepage also there. Means plastering in the down seabed, canal bed, the side bunds also, it will be plastered. But if the plastering material is not proportionately made, after some times the plastering will go away, and the water leakage and it goes, percolation of the water would be there. So most of the water goes in the percolation. Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be.
Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।